I want to talk for a second about why I think content like this actually matters, beyond just being interesting to talk about. There's a real meaningful gap between people who have easy access to legal knowledge, whether through education, profession, or family background, and people who don't, and that gap has real consequences in real situations. It's not fair, and it's not something any individual video is going to fully fix, but I do think there's genuine value in narrowing that gap even a little, one plain language explanation at a time, for anyone willing to spend a few minutes actually learning something instead of relying on guesswork or half-remembered fragments picked up secondhand. That's the actual mission behind this, as unglamorous as that sounds, not to turn anyone into a lawyer, but to close the specific, practical gaps that leave ordinary people at a disadvantage in moments that matter. All right, let's keep working on exactly that with today's topic. You're standing somewhere, maybe your living room, maybe your kitchen, maybe you just walked in from work and set your keys down, and your phone buzzes with a text from a friend that says something like, "Hey, just so you know, there were cops on your street earlier." And something in your chest tightens a little, even though you haven't done anything wrong, even though you can't immediately think of a single reason why any of this would have anything to do with you specifically. That tightening happens because most people carry, somewhere underneath their everyday awareness, a vague, uncomfortable sense that they don't actually know what to do if an officer ever walks up and starts asking questions. Not a dramatic, movie version encounter, just a regular Tuesday afternoon, a badge, and a question. That uncertainty is what this video is here to fix, completely, from the ground up, so that whether you're ever approached on a sidewalk, stopped in a parking lot, questioned outside a store, or pulled into a conversation you didn't expect and didn't plan for, you know exactly what your rights are, exactly what your options are, and exactly what to say, calmly and confidently, in real time. Before we get into any of it, if you want to understand how these encounters actually work instead of guessing your way through them, subscribe right now, because that's what this channel exists to give you, one real scenario at a time. And quick note before we start, this is legal education and commentary, not legal advice for your specific situation, and details can shift depending on where you live. But the core principles we're covering today are grounded in constitutional law that applies across this country. Let's get into it. Let's start with the thing that actually matters most, the one piece of the puzzle that changes everything else about how any of this works. When an officer walks up to you and asks for your ID, the most important word in the entire interaction, the one you almost certainly weren't told about in school, the one that determines whether you have an obligation at all, is context. Because whether you are actually required to hand over identification, whether you have to answer questions, whether you have to explain yourself or justify your presence or account for where you've been and where you're going, all of it depends almost entirely on the context of the encounter. Specifically, what kind of legal interaction you are actually in at that exact moment. There are not an unlimited number of possibilities here. There are essentially three distinct categories of police encounters that you can be in at any given moment, and they carry dramatically different sets of rules, and knowing which one you're in right now, in real time, is the single most valuable piece of information you can have during any of these interactions. So let's walk through all three, carefully, because this is the entire framework everything else in this video is built on top of. The first category is what lawyers call a consensual encounter. This is the most common type of police interaction, and it's also the most misunderstood, because it looks and feels like an official, mandatory thing even though it is, legally speaking, entirely. If understanding your rights clearly, instead of just vaguely, is something that matters to you, I'd really appreciate it if you hit subscribe before you go, because that's exactly what this channel is built around, one real, specific legal topic at a time, explained in plain language without the unnecessary complexity. It genuinely helps more than you'd think, mostly because it tells me this kind of plain language legal content is actually reaching the people who need it, which is the entire point of doing this in the first place. All right, that's the ask. Let's keep going. Voluntary from your side. A consensual encounter is exactly what it sounds like. An officer walks up and starts talking to you, but there is no detention, there is no legal requirement for you to be there, and there is no legal obligation for you to respond. The officer can approach you on the street, in a parking lot, outside your workplace, in a store, anywhere in a public space, and simply begin a conversation. And in a consensual encounter, You have the same freedom to end that conversation and walk away that you'd have with any stranger who stopped you on the sidewalk. You can say, politely, "Am I free to go?" And if the answer is yes, you can go. You can decline to answer questions. You are not required to hand over your identification. None of that is obstruction, none of it is suspicious behavior under the law, and none of it gives the officer grounds to escalate the situation, simply because you decline to participate voluntarily. The second category is what's called an investigatory stop, sometimes referred to as a Terry stop, named after the Supreme Court case Terry v. Ohio, which established the legal standard that governs it. This is a different situation, and it carries a different set of rules. An investigatory stop happens when an officer has what's called reasonable articulable suspicion, meaning a specific, concrete, explainable reason to suspect that you specifically have been involved in, are currently involved in, or are about to be involved in criminal activity. It's a legal standard and it's a meaningful one, which means it's not met by a vague feeling, not met by the fact that you happen to be in a certain neighborhood, not met by the way you look or the car you drive, and not met by the officer simply thinking something might be off without being able to put a specific, articulable reason behind it. If an officer has genuine, reasonable, articulable suspicion, they are permitted to briefly detain you to investigate, not arrest you, not search you without additional justification. Briefly detain you, which means you're not free to simply walk away the way you would be in a consensual encounter, though even in this category, you still have significant rights about what you're required to say and provide, which we'll get to in detail. The third category is an arrest. An arrest requires probable cause, a significantly higher and more demanding standard than reasonable articulable suspicion, and once you're under arrest, an entirely different set of rules kicks in, centered on Miranda rights and the right to counsel, which deserves its own careful treatment, and which we'll get into properly later in this video. Understanding which of these three categories you're in during any given moment of any given encounter is the foundation of knowing what you actually have to do, what you're allowed to decline, and how to protect yourself legally while the interaction is still unfolding. So let's talk about how to figure out which category you're in, because it's not always obvious, and the transition between categories can happen quickly. The simplest and most effective way to determine where you stand is to ask, directly and politely, "Am I being detained, or am I free to go?" This single question forces a clarification that matters enormously, both for you in the moment and for anyone looking at the encounter afterward. If the officer says you're free to go, then you're in a consensual encounter and you can leave. If the officer says you're being detained, then you're in an investigatory stop at minimum, and the conversation shifts accordingly. If the officer gives a non-answer, something vague or deflecting, you're allowed to ask again, calmly, "I just want to make sure I understand. Am I being detained?" That's a reasonable question, stated respectfully, and it's one you are entirely entitled to ask. Now let's get into the specific question of identification, because this is what the title of this video is about, and it's where a truly enormous amount of confusion lives. Confusion that sometimes leads people into serious, preventable problems because they didn't know what they were actually required to do versus what they felt socially pressured to do. Here is the core legal reality about ID requirements in this country. There is no uniform nationwide rule that says you must provide identification anytime any officer asks for it. What there is instead is a patchwork of state-level laws that govern this specific question, and those laws vary significantly depending on where you are standing. This is genuinely important, and it's worth saying again clearly, because a lot of people believe that handing over ID when asked is simply a universal legal obligation, and that belief is incorrect. Some states have what are called stop and identify statutes. These are laws that require you, in specific circumstances, to provide your name or identification to an officer who has legally detained you on the basis of reasonable articulable suspicion. As of what we know about existing law, roughly half the states in the country have some version of a stop and identify statute, and they vary in their specific requirements, some requiring only your name, some requiring identification documents, some applying specifically to drivers, some applying to pedestrians, and some making failure to identify a criminal offense, and others treating it as a lesser infraction. Other states have no such statute at all, meaning that even in an investigatory stop, you may have no legal obligation to provide identification beyond a name, depending on the specific state law where the interaction is happening. The first thing worth knowing before you ever need it is whether your specific state has a stop and identify law, and if so, what exactly it requires, and under what circumstances it applies. This is publicly available information. It takes less than 5 minutes to look up, and knowing it in advance means you're not trying to remember whether you have an obligation while an officer is standing 3 feet away asking you a question. We're going to talk about the general framework as it applies in stop and identify states throughout this video, and we'll address the differences for non-stop and identify states as we go. Let's talk about what happens in a straightforward investigatory stop in a stop and identify state, because this is the scenario most people picture when they think about being asked for ID, and it's worth walking through carefully. If an officer has detained you, meaning you are not free to go, and they ask for identification, and you're in a state with a stop and identify statute, then you generally do have an obligation to provide your name and potentially your identification, and refusing to do so in that scenario can have real consequences. This is one of those moments where knowing the law precisely is exactly what protects you, because the response that protects you here is not refusing to give your name, it's giving your name, clearly and calmly, while simultaneously and clearly not volunteering any additional information beyond what the statute specifically requires. The distinction between what you're required to provide and what you choose to provide beyond that is the center of gravity for the entire identification question, and it's worth dwelling on for a moment because it's the thing most people completely miss. Providing your name or your ID in states where that's specifically required during a valid detention is one thing. Answering follow-up questions about where you've been, where you're going, what you were doing earlier today, who you were with, what's in your bag, what your plans are for the evening, none of that is covered by a stop and identify statute. None of that is required simply because you're being detained. Providing your name, if required, does not open the door to a full interrogation, and everything beyond your name can still be declined, calmly and clearly, with something as simple as, "I've provided my name, but I'd rather not answer additional questions right now." Let's talk about the traffic stop specifically, because it operates somewhat differently from a pedestrian encounter, and it's the scenario most people are statistically most likely to find themselves in. When you're driving a vehicle and you're pulled over, you're operating under a different set of expectations than when you're walking down a street, because driving is a licensed activity, regulated by the state, and as a condition of being licensed to drive, you've agreed to carry and produce on request certain documents, specifically your driver's license, registration, and proof of insurance. This is not the same as the general ID question in pedestrian stop and identify states. It's a condition of the licensed activity of driving, and it applies almost universally across the country for licensed drivers operating a vehicle on public roads. When you're pulled over in your car, producing your license, registration, and insurance is generally required and is the right move, and there is very little legal ground for refusing that specific request in a traffic stop context. What matters in a traffic stop, and where the parallel to everything else we're discussing kicks in fully, is everything after those documents have been handed over. Once you've provided your license, registration, and insurance, the same fundamental principle applies. You are not required to answer additional questions. You are not required to explain where you're going or where you've been. You're not required to account for your passengers. You're not required to consent to a search of your vehicle. You're not required to roll your window all the way down beyond what's needed for communication if your local norms allow partial compliance. Every right that applies to the identification question in a pedestrian encounter applies with equal force to the question and answer phase of a traffic stop, and it's in that phase where most of the legally significant things that can help or hurt you in a traffic stop actually happen. Let's talk about what to actually say, because principle is important, but specific language under pressure is what actually protects you when the moment is real and happening. There's an enormous difference between knowing intellectually that you don't have to answer questions and having an actual sentence ready to say out loud, calmly, without stumbling over it, without sounding confrontational, and without creating unnecessary friction in what might otherwise be a brief and uneventful interaction. If an officer walks up to you in a public space and begins talking to you, and you're trying to figure out whether this is voluntary, the first thing is always that simple, polite, clarifying question, "Am I free to go?" If the answer is yes, you can say, "I appreciate that. I'd like to head out," and leave. If the answer is no, you now know you're in a detention, and the conversation shifts. In a stop and identify state where you're detained, give your name clearly, calmly, and without elaboration. If the statute requires more than a name, like showing an actual ID document, produce it calmly. Once you've done that, the sentence that carries the rest of the encounter is simple. "I've given you my information, but I'd rather not answer any additional questions without speaking to an attorney first. That sentence is complete. It's legally sound. It asserts your Fifth Amendment right against self-incrimination without being dramatic or confrontational about it. And it closes the door, firmly and politely, on the open-ended question and answer session that follows most requests for ID. You might get pushback. We're just trying to get a few quick facts straight. You're not in any trouble. I just need to understand what happened. This'll go a lot faster if you just cooperate. None of those statements change anything. None of them are legally meaningful in the sense of creating an obligation that didn't exist a moment ago. Your response to any of them is simply a calm repetition of what you've already said. I understand, but I'd still rather not answer questions without speaking to an attorney. You don't have to argue. You don't have to justify the decision. The sentence stands on its own. Let's talk about why the instinct to explain yourself is so powerful and so dangerous in these moments. Because this is the piece that catches honest, completely innocent people off guard more than almost anything else. When someone looks at you, especially someone in uniform with a badge, and implies that you're behaving suspiciously by not answering their questions, the social pressure to prove that you're innocent, to demonstrate through words and openness that you have nothing to hide, is genuinely intense. It doesn't feel like pressure in the usual sense. It feels like the obvious, reasonable, human thing to do. Of course you'd explain yourself to someone who seems to think you might have done something wrong. Of course you'd tell them where you were and what you were doing and why it's all perfectly normal. Because it is perfectly normal, and the explanation should clear everything up. Except that's not how it works. And that gap between how it feels and how it actually works is exactly where good, honest, innocent people create serious problems for themselves. Talking to officers without counsel present, even when you've done absolutely nothing wrong, creates risks that don't exist when you stay quiet. Memory is imperfect, and small inconsistencies between what you say now and what any other evidence shows later can look significantly worse than they actually are. You don't know what information the officer is already working with, which means you don't know which parts of your innocent explanation might happen to contradict something else in a way that complicates your situation. You can accidentally provide context that, stripped of its full meaning, sounds much more problematic than the actual underlying reality. And none of this requires any bad faith on anyone's part. It's simply how the mechanism of this kind of conversation works in practice, and the protection built into the Fifth Amendment exists precisely because the founders understood this risk, not because they thought guilty people deserved to avoid accountability, but because the system of truth-finding that actually works correctly is the one that happens in a courtroom with all the procedural protections intact, not in a parking lot on a Tuesday afternoon without any of them. Let's talk about something that a lot of people get specifically confused about, which is the difference between invoking your right to remain silent and actually remaining silent. Staying completely silent throughout an encounter, without saying anything at all, is not the same as clearly invoking your right to remain silent, and in some legal contexts, particularly after an arrest, the Supreme Court has made it more complicated than simply staying quiet. The cleaner, more legally solid approach is to say it out loud, once, clearly, I am invoking my right to remain silent, and I'd like to speak with an attorney. Those two parts together, the right to silence and the request for counsel, are the combination that most robustly triggers the protections that are available to you, and saying them clearly means there's no ambiguity later about whether you were trying to invoke them or simply hadn't gotten around to answering yet. This is true even if you're in a consensual encounter and technically not in a situation where Miranda warnings apply. Because clearly stating that you're not answering questions closes the conversational door in a way that pure silence sometimes doesn't in practice, even if pure silence would be your legal right. Let's talk about the specific dynamics of what happens after you invoke, because this is where many people's resolve starts to crack, not because they've changed their minds about their rights, but because the interaction doesn't end the moment they invoke. Officers can continue to speak to you. They can repeat questions. They can make statements designed to prompt a response. Things like, your friends already told us everything, so you might as well give us your side. Or, we know what happened, we just need to hear it from you. Or, if you didn't do anything wrong, there's no reason not to tell us about it. None of these statements change your legal situation. None of them are reasons to start answering questions after you've invoked. The sentence you already said is still standing, and every time you feel the pull to respond to one of these prompts, the thing to recall is that the statement you made when you invoked is still legally operative, still protecting you, and the moment you start responding to questions, you've effectively withdrawn it, whether or not you intended to. This is genuinely one of the hardest things to actually do in practice, because the human instinct to respond when spoken to is almost physically difficult to override. That's not a character flaw. It's just how human conversation works, and it's something officers who conduct these interviews are very much aware of and trained around. The quiet that follows your invocation is not comfortable for you, but it is correct, and it is protecting you in a way that continuing to engage does not. Let's talk about a specific scenario that deserves its own careful walkthrough, which is being approached and questioned in connection with something that happened near you, but that you weren't involved in. Someone got into an altercation in a parking lot near your car, and you happened to be there. There was an accident on a road where you were also driving. A crime happened somewhere in a neighborhood you were walking through. In each of these cases, an officer might approach you as a potential witness, not as a suspect, and ask if you saw anything. And here's where the analysis gets genuinely nuanced, because there's a meaningful difference between being a witness and being a suspect, and the question of which one you are isn't always something you know clearly at the beginning of that conversation. You are not required to speak to officers as a witness any more than you are as someone being investigated yourself. There is generally no legal obligation for ordinary civilians to provide witness testimony to police in the street. You can say, "I'm not comfortable answering questions right now, but I understand how to get in touch if that changes." And that is a complete response. This might feel strange if you genuinely do have information that would help, and in those cases, you have every right to make the choice to speak voluntarily. Because voluntary cooperation in a genuinely consensual encounter is absolutely your choice to make. The important thing is understanding that it is a choice, and that the choice is yours, rather than something that's been demanded of you by the fact of the officer's presence. Where this gets complicated is the scenario where the investigation shifts, where you begin the interaction as a potential witness, and the officer's line of questioning starts moving toward your own conduct. This shift can happen gradually, even conversationally, in a way that doesn't feel like a dramatic change in the moment, but that puts you in a very different legal position than where you started. The safest approach, and the one that leaves you the most options throughout, is to ask that clarifying question early. Am I a suspect here, or am I being detained? Because if the answer is no, you're in a consensual encounter, and everything is voluntary. And if the answer becomes yes, or if the questions start feeling like they're moving in that direction, that's when "I'd rather speak with an attorney before I answer any more questions" becomes the right sentence, regardless of where the conversation started. Let's talk about photography and recording specifically, because it comes up constantly in conjunction with these encounters, and it's a right worth understanding clearly. In public spaces, in the vast majority of circumstances and jurisdictions across this country, you have the right to photograph and record video of officers performing their duties. This right has been addressed repeatedly in federal courts and affirmed as protected activity under the First Amendment. Officers cannot legally order you to stop recording, cannot confiscate your phone without a warrant, and cannot use the act of recording as the basis for detaining or arresting you, though we live in a complicated world, and knowing your right doesn't guarantee every officer in every moment will respect it. What it does mean is that if you are legally recording and an officer demands that you stop, "I'm legally recording in a public space, and I'm not going to stop," is a statement you're entitled to make, calmly, once, without raising your voice, or making the recording the center of a confrontation that doesn't need to be one. In terms of how recording connects to everything else we've covered, having a record of exactly what was said, exactly how the encounter began, exactly what question was asked, and exactly what you answered, is one of the most powerful protections available to you in any encounter with police. Memory is fallible and selective. A video recording is not. If there's ever a dispute later about whether consent was given, whether you were told you were free to go, whether a particular warning was delivered, a contemporaneous recording settles that dispute in a way that competing memories simply cannot. Let's talk about what to do immediately after an encounter ends, because the minutes right after it's over are more important than most people give them credit for. As soon as you're safely away, and not in immediate conversation with any officers, write down or record a voice memo with everything you can recall. The time, the location, the number of officers, what they were wearing, any badge numbers or names you caught, exactly what questions were asked, exactly what you said in response, whether you were touched at any point, whether you were told you were free to go or told you were being detained, and the general sequence of events from beginning to end. Memory begins fading and filling in gaps almost immediately after a stressful event, and those notes, taken while everything is still fresh, become genuinely valuable if anything about the encounter turns out to matter later, whether that's in a criminal proceeding, a civil rights complaint, or a conversation with an attorney about your options. Let's talk about something worth addressing specifically and carefully, which is the way race, appearance, and other factors affect the reality of these encounters, beyond just the legal framework. The legal rights we've been discussing throughout this video apply to every person, uniformly, regardless of who they are or what they look like. The practical reality of how encounters unfold in the real world, the statistical likelihood of being stopped, the tone in which questions get asked, the willingness of officers to accept a polite invocation of rights without escalating, can vary in ways that the law itself doesn't create, but that are genuinely present in lived experience. This video is about the legal framework, because that's what we can give you in this format, and the legal framework genuinely matters and genuinely protects you when properly invoked. We also think it's worth naming, honestly, that knowing your rights and being in a position where invoking them goes smoothly aren't always the same thing, and if your experience with police encounters has involved dynamics that go beyond the clean legal questions we've covered here, that's a real and serious thing, not a side note. Let's talk about the Miranda question specifically, because this is one of the most widely known legal concepts in the country, and simultaneously, one of the most misunderstood in terms of when it actually applies. Most people know the phrase, "you have the right to remain silent," because it appears in essentially every television and film depiction of an arrest that's ever been made. What most people don't know is the specific legal trigger for when officers are required to deliver Miranda warnings, because it's not what most people assume. Miranda warnings are required when two things are both true at the same time. You are in custody, meaning a reasonable person in your position would not feel free to leave, and officers are about to interrogate you, meaning they're about to ask you questions designed to elicit information that could be used against you. Both conditions have to be present. This means that officers approaching you in a consensual encounter don't trigger Miranda, because you're not in custody. It means that officers arresting you but not asking you questions don't trigger Miranda in that moment. And critically, it means that statements you make voluntarily, without being questioned, aren't covered by Miranda, because the interrogation condition isn't met. This is why anything you say can and will be used against you is true even before any formal Miranda warning has been delivered, because voluntary statements don't require Miranda to be admissible. What this means practically is that the protection Miranda represents, specifically the right to remain silent and the right to counsel, are rights you should be actively invoking on your own behalf, verbally and clearly, rather than waiting for officers to tell you about them. Officers are required to tell you before custodial interrogation, but they may delay arrest, they may keep an encounter at the level of a consensual conversation to avoid triggering the formal warning requirement, and in the time before any formal custody is declared, everything you say is potentially usable, which is exactly why the approach we've outlined throughout this video, invoking your right to silence and your right to counsel clearly and early, protects you more robustly than waiting for someone else to do it for you. Let's talk about something that trips people up at the border, and in airports specifically, because encounters in those contexts operate under different rules that deserve their own mention. At ports of entry, international airports, and border crossings, Customs and Border Protection has significantly broader authority than local or state police in a typical street encounter. If you're a U.S. citizen returning from international travel, you are generally required to identify yourself and declare goods. You're not required to unlock your phone or hand over passwords, and that specific area of border search law is actively litigated and evolving. If you're not a U.S. citizen, the considerations are even more significant and specific to immigration status in ways that go well beyond what this video can cover adequately. The border context is genuinely different enough from the standard street encounter or traffic stop that if you travel internationally frequently, it warrants its own research specific to your situation and status. Let's talk about what to do if you believe an officer has violated your rights during an encounter, whether that's conducting a search without consent or a warrant, detaining you without reasonable articulable suspicion, using excessive force, ignoring your invocation of your right to silence, or any other specific conduct that crossed a legal line. The answer here is important and often counterintuitive. The place to address it is not the side of the road or the parking lot while it's happening. The place to address it is afterward, with an attorney, through the proper legal channels, whether that's a motion to suppress evidence that was illegally obtained, a civil rights complaint, or litigation. Attempting to physically resist, verbally escalate, or otherwise challenge what you believe is an illegal action in the moment carries enormous risks that almost always outweigh whatever immediate point might be made, and courts are generally better positioned to evaluate what actually happened with proper evidence and procedure than any roadside confrontation is going to allow. This isn't about accepting injustice or letting rights violations go unanswered. It's about understanding where the actual leverage is. An attorney reviewing documented evidence of an illegal stop, an improper search, an ignored invocation of rights can do vastly more with that material in a courtroom than the version of you in that parking lot can do by arguing in the moment. Comply in the moment, document everything, and fight it in the venue that actually has the power to provide a remedy, because that's the approach that actually works. Let's talk about the question of consent specifically and completely, because consent is the hinge on which so much of this entire conversation turns, and the law around consent in police encounters has a lot of nuance that's worth understanding in detail. Consent to search, for example, is generally considered voluntarily given in a wide range of circumstances that might not feel voluntary to the person giving it. If an officer asks, "Can I look in your bag?" and you say yes, that's almost certainly going to be treated as voluntary consent, even if you felt pressure you didn't feel free to refuse, unless the circumstances were extraordinarily coercive. The legal standard for consent being involuntary is quite high, which means the practical protection of your right not to be searched without a warrant depends almost entirely on you actually saying no, clearly, rather than relying on a court later to determine that your yes wasn't really voluntary. "I don't consent to a search," is the sentence. Those 5 words, said calmly, said clearly, without elaboration or explanation, because explanation opens the door to follow-up questions and potential complications, and those 5 words, standing alone, accomplish everything they need to accomplish. You don't need to explain why you don't consent. You don't need to justify the decision. You don't need to make it about having something to hide or not having anything to hide. It's simply the exercise of a right, and exercising a right requires no justification. If an officer proceeds to search anyway after you've said those words, which can happen in situations where they claim to have grounds that don't depend on consent, the most important thing at that point is to not physically interfere while making absolutely clear for the record that you have not consented. "I don't consent to this search," repeated calmly, even as it proceeds, creates a clean record that no consent was given, and that record is what an attorney needs to challenge the search properly later, if it turns out the claimed grounds for the warrantless search didn't actually exist. Let's talk about the specific dynamics of a situation where there are multiple people present, because group encounters carry their own set of complications. If you're stopped with friends, or in a group, each person's legal situation is technically independent, meaning the fact that one person consents to something doesn't obligate you to, and the fact that one person starts answering questions doesn't mean you've implicitly waived your right to decline. What this looks like practically is that if officers approach a group you're part of and someone else in the group starts talking freely, you are still allowed to quietly and clearly say, if asked, "I'd rather not answer questions right now." Your choice is yours, independent of the choices others around you are making, and the fact that the group conversation is happening doesn't sweep you into it. What this also means is that if you're with someone else and you know in advance that you both understand and agree on this approach, you're much better positioned than if one person knows these rights and the other is responding to every question instinctively. The best version of this conversation happens before anyone is ever in the situation, in a calm moment, between people who might find themselves in encounters together, not in the stressful real-time moment when an officer is present and asking things. Let's talk about what happens at a DUI checkpoint, because this is a specific and somewhat unique context that operates differently from a routine traffic stop, and it's one where the right questions and right responses matter in specific ways. Checkpoints are generally considered constitutional under a set of limitations the Supreme Court established, and at a checkpoint, officers can briefly stop vehicles without individualized reasonable suspicion, which is different from a standard traffic stop. However, that doesn't transform the encounter into one where all the usual rights evaporate. You are still required to provide your license and registration. You are still not required to answer questions about where you've been or whether you've had anything to drink. And "I'd rather not answer questions," stated calmly, is still your right. Field sobriety tests in most states are something you can decline, though refusal often comes with administrative consequences tied to implied consent laws, which vary state to state and which affect your driving privileges rather than triggering immediate criminal liability, though that distinction gets complicated quickly. If a checkpoint interaction is escalating in a direction that feels like it's moving toward an investigation specifically of you, the same framework applies. Say clearly that you're invoking your right to remain silent and that you'd like to speak with an attorney before answering questions. Let's talk about something that doesn't get enough attention, which is the dynamic that exists in encounters that happen in stores, restaurants, bars, and other private businesses. If a business's own security personnel approach you, the Fourth Amendment, which limits government actors, doesn't directly apply to them the way it does to officers. Private security can ask you to leave, can detain you briefly in some circumstances related to suspected shoplifting under what are called shopkeepers' privilege doctrines, but generally cannot arrest you, cannot search you without your consent, and cannot detain you for extended periods. If a situation involves private security and then transitions to actual police being called, the moment an officer is present and involved, the framework we've covered throughout this video applies fully. Before that point, with private security only, the practical approach is often still to stay calm, not answer questions, and understand that their authority is significantly more limited than they may present it as being. Let's talk about the role of an attorney in these situations, not just the abstract right to counsel, but the practical reality of what it means and when to actually seek legal help. The right to an attorney in criminal proceedings is constitutionally guaranteed and well established. The question of when to actually invoke that right, and when talking to an attorney before any formal proceeding would be valuable, is a more practical question. The answer is, almost always, if anything about an encounter felt significant. If you were detained, if you were questioned in any way that felt like it was about your potential involvement in something, if your home or car was searched, if you were asked to come in voluntarily to talk about something, each of these is a situation where speaking with an attorney before doing anything further costs you little and potentially protects you from a great deal. An attorney can help you understand whether your rights were violated, what your options are, whether and how to respond to any follow-up from law enforcement, and what the actual legal landscape looks like for your specific situation, which is the kind of specific guidance that general legal education can't replace. Let's talk about how to find an attorney quickly if you need one, because knowing you have the right to counsel is one thing, and actually having someone to call is another. Having the name and contact information for a criminal defense attorney saved in your phone before you ever need it is the practical version of believing in this right. Public defenders are available if you can't afford private counsel, but they're assigned after charges are filed, not during the investigatory phase where some of the most consequential decisions get made. If your financial situation allows for it, having a brief consultation with a criminal defense attorney in your area, just to know who they are and how to reach them, is one of the most useful things you can do with 30 minutes and a modest fee, the same way having a doctor you know to call if you get sick is more useful than having to find one in the middle of feeling terrible. Let's talk about young people specifically, because there's a version of all of this that plays out with additional stakes and additional complications when the person being questioned is a minor. In general, the constitutional rights we've covered throughout this video apply to minors as well as adults. The right to remain silent, the right to refuse a search without consent, the right to counsel, all of these exist regardless of age. What's different is that in practice, young people are often in situations where they feel even less empowered to invoke these rights, sometimes in school settings where the relationships with authority figures are complex and embedded in their daily lives, and sometimes with parents present who are also uncertain about the right approach. If you have young people in your life, having this conversation with them explicitly, in age-appropriate terms, before they're ever in a situation where they need it, is genuinely one of the most protective things you can do for them. The same principles apply, the same sentences work, and the same underlying truth holds, that knowing your rights in advance is what makes them real, rather than just theoretical, when the moment arrives. Let's talk about what the arc of this whole framework looks like when you put it all together, because I want you to have a clear, complete mental picture of it that you can actually recall in sequence if you ever need it. Something is happening. An officer is approaching, or has approached, or has stopped you, or is asking for your ID and questions are starting. The first thing you do is breathe, because the pause before you say anything is valuable. The second thing you do is figure out which category you're in by asking, clearly and simply, "Am I free to go?" If yes, you thank them and you leave. If no, you now know you're being detained, and you ask what the basis for the stop is, because you're entitled to know what reasonable articulable suspicion is claimed to exist. You provide your name if you're in a stop and identify state and are being detained, and your license, registration, and insurance if you're driving, because those are required. Everything beyond that, you decline. Clearly and calmly, "I've provided what I'm required to provide, and I'd like to invoke my right to remain silent and speak with an attorney before answering any questions." From that point forward, you repeat that position as many times as necessary, without raising your voice, without arguing, without elaborating, and without allowing the discomfort of the silence or the pressure of the questions to walk you out of the position you've correctly taken. You do not consent to a search. You do not answer follow-up questions. You comply physically with any lawful commands, like stepping out of a vehicle if directed, but you make clear that complying with a physical directive is not the same as consenting to a search or waiving any other right. After the encounter ends, you write everything down immediately. You contact an attorney if anything about it feels significant, and you preserve all of it, your notes, any recording, any documentation, because if anything about the encounter was improper, that material is what an attorney needs to actually do something about it. That's the complete picture. Not complicated, not requiring extraordinary courage or confrontational language, just a clear, calm, sequential understanding of where you stand and what you're actually required to do versus what you're being socially pressured to do, because those two things are very often not the same. Let's talk about one more thing before we wrap up, and it's the thing that underlies all of it. The reason any of this matters enough to spend this kind of time on. These rights exist because people before us decided, deliberately and after a great deal of hard experience, that ordinary people need a specific set of protections when the power of the state is pointed at them directly. They put those protections in writing, in the Constitution, in the Fifth Amendment, in the Sixth Amendment, in the Fourth Amendment. Not as abstractions, but as actual operative law that courts have to apply and that officers have to work within. Those protections are not weaknesses in the system. They are the system, the part of it that exists specifically to protect you, individually, when no one else is going to. Invoking them is not anti-police. It's not a declaration that you've done something wrong. It's not obstruction, it's not suspicious, and it's not something that makes you a bad neighbor, a bad citizen, or a difficult person. It is the simple, quiet exercise of something that was built specifically for you to use. Built. All right. That's where we'll leave it for today. I hope this gave you something genuinely useful, not just interesting to hear, but something you could actually use if the right situation ever came up. That's always the real goal here, understanding you can actually carry with you, not just information you forget by tomorrow. Take care of yourself, know what's actually yours, and I'll see you in the next one.